My name is Marcus Harris. I'm a Chicago-based software and intellectual property attorney. Since 1999, I focused my practice on drafting and negotiating ERP-related contracts and litigating failed ERP implementations in courts across the country. Prior to forming my own practice, I worked in the legal departments of SAP and Infor. I understand what it takes to sue software vendors, and I understand how software vendors operate. One of the causes of action we typically bring against a software vendor for a failed implementation is a claim for breach of contract. And if a software implementation is going to fail, it will usually fail because the software vendor failed to provide services in accordance with its contractual obligations under an implementation contract. And the basis for asserting a claim for breach of contract can be anything from the software vendor failing to provide services in accordance with generally accepted industry standards, the software vendor failing to provide a good faith estimate of the overall cost of the software implementation, the software vendor providing incompetent consultants, missing deadlines, providing non-conforming deliverables, or missing functionality. One of the other causes of action we will bring against a software vendor for a failed implementation is a breach of something called the duty of good faith and fair dealing. Now, in order for us to make a determination as to the viability of any of these claims, what we do usually is hire a third-party software implementation expert who will review the documentation from the implementation. They will review documentation from the sales cycle and help us ascertain the viability of moving forward with a lawsuit with a cause of action for breach of contract against the ERP vendor. Now, if you have any questions about any of the issues in this video or any of our other videos, please feel free to give our office a call at 312-263-0570. Thank you.